Good afternoon, my name is Nick Polishkin. I'm a broker with Vera Realty. Welcome to Vera Realty Real Estate Contract Tutorial. Today we will review as-is residential contract for sale and purchase, and we'll focus on parts which can be edited and customized. For everybody, I'm not a lawyer and this is not legal advice. This is for information purposes only. If you have questions about legal parts of the contract, please contact an attorney. After this tutorial, please make sure you read the contract on your own a few times and watch the tutorial again after that. Your clients will always have questions about contracts. Most of the time, this is the contract which you will fill out for a residential purchase of single-family property, house, or for multi-family units in condominiums or apartment complexes. So let's begin. This is how it looks on the first page of as-is contract, and we actually will fill it out. So if you go to your dashboard, we are with Miami Association of Realtors, but also Vera Realty, part of Real Estate Association of Palm Beaches and Fort Lauderdale. But you usually will have access to your files from Form Simplicity, as it's available to all realtors and all agents. In our company, we use .loop system, so I will be showing you how to fill it out within .loop. And you go to templates, or let's just create a new loop. So when you're working with a buyer, and let's say you will be representing a buyer, let's say your dad, right, for example, and then we'll find, we need to select a template. Will be new contract, buyer, condo, townhouse. In our case, because we will be using this property as an example. This is one of our investment properties, and this is a condominium, or no apartments condominium. So over here, you select that, create a loop, and name the loop by the name of the file. The address of the property. Okay, paste, create. So it will create a new loop for you. Select a status, pre-offer, and then it will upload all the documents which you will need. One of them will be as-is residential contract over here. Another one is homeowners association community disclosure. This is in case, and condo association addenda. This is in case if it's in the association, and we will need one of these two. Pre-1978 lead-based paint, and you see on the left-hand side it says optional, required, required, optional, optional. So whatever is required, it's a must to submit with an offer. What's optional, depends. 1978. So we look at the property, it's 1981. So we don't need to worry about that. Vera Realty client disclosure. For buyer, this is in case if your buyer willing to pay the transaction fee. And it's also optional. So we're going to start with the contract. Open it up. You can pre-type some of the fields over here, and also because that loop is connected to our MLS, Miami MLS, you can try to see if it will pull some of the information from the MLS. So what you do, you need to copy and paste the listing, the MLS number, over here, and see if it will pull up any information. It's not, maybe because it's canceled, maybe if it was an active listing, sometimes as soon as you type it in, it will show you like information down here, and you can click on that and it will copy and paste some of the information. But actually, we can still pre-fill some of it, but we can do it in the contract as well, so you can see the parts of it easier. So seller, first field. So we need to go to the MLS. How you can find the seller? You can find it in the IMAP, and also you can find it in Property Appraiser. And it's good to check in both places. So we click on the property ID number, and it will take us to IMAP, and then to check on the Property Appraiser, you click on the property ID again, and it will take you to the Property Appraiser. So this is the owner, LLC, and the same owner over here. So we're good, and we can paste it here, post LLC, buyer. So let's say your dad, and then, or it can be you yourself. Then street address, same thing, just copy and paste from the MLS, or you can do it from the property appraiser in the IMAP. Hmm? If you represent seller, or I mean, if you represent seller, you're not going to prepare the contract in the first place because you're waiting for the offers. Yeah, they will send you the offer. They will send the contract. Yes. When you present seller, you will receive this contract, and you will see already what's the buyer's name, and you will see all the details. So next one is located in county, and you can check it over here too, Broward County. Then tax ID, property ID number, same thing. We go to either one, MLS, IMAP, or the property appraiser. And this is very important too, to make sure it's correct, because sometimes, let's say you put the address wrong, or you messed the apartment number. Yeah, the address, and at the closing this will come up, but usually, still the title company will go by the property ID number, they will double check it. And sometimes the listing agent will put the address wrong, for example, on the land. In the apartments and houses, it's more rare, but especially in the land deals, they can, mess up the listing ID, or the listing address. Then the legal description. So to find the legal description, you go to IMAP as well, and it's down here. Good. Next item is personal property. So unless excluded in paragraph 1E or by other terms of this contract, the following items which are owned by seller and existing on the property as of the date of the initial offer are included in the purchase: ranges, oven, refrigerator, dishwasher, disposal, ceiling fan, intercom, light fixture, drapery rods and draperies, blind, window treatments, smoke detectors, etc. Other personal property items included in this purchase are: so if the seller, or there is some additional information in the listing talking about additional personal property, furniture, anything else, write it here. Next paragraph is that the following items are excluded from the purchase. So list everything what's excluded. For example, owners want to take their own washer and dryer. So stated here that they excluded from this purchase agreement. So at the end, at the closing day, nobody will have issues or misunderstandings when you go for the walkthrough and there is no washer and dryer. Then we move to purchase price and closing. So purchase price, if you're making an offer, and this contract is usually when you're presenting an offer to buy, sometimes you will be presenting counter offer. So here you need to state your purchase price. Before that, you need to do your CMA analysis for your clients. In our case, listing price was $99,000 here, so we're making an offer, let's say, for $90,000. But of course, you need to do your due diligence, do the CMA, and justify that price for your clients and offer them what to present. So I'll put $90,000. Letter A here is initial deposit to be held in escrow in the amount, check subject to collection, initial deposit made, payable, and delivered to escrow agent named below, and there are two options. So it accompanies the offer. So this is in case if you already have the check from your clients with the initial deposit, and let's say initial deposit will be here $10,000. And your clients already gave you the check, you brought it to the office next day and gave it to your office manager or the escrow manager. That's in case if you already have a check. If you don't have a check yet, you can discuss it with your buyers and you can put 3 days or 5 days, depends on the situation. If you leave it blank, it will be 3 days by default. If neither box is checked, then option 2 shall be deemed selected. So if you forgot to check any of the box, it will be option 2 by default and it will be 3 days. So in 3 days, deposit has to be in escrow. Escrow agent information and name. In my brokerage, we have an escrow account, so I'll type in our information. In your case, it can be your title company, it can be your lawyer or buyer's lawyer. So there's lots of options here. 355 South Ocean Drive. This is our address. Our phone number. We don't have a fax. Okay, so next, letter B is additional deposit to be delivered to escrow agent within 10 days if left blank. And if you're delivering additional deposit, let's say after 10 days or 15 days, in our case, we will have 15 days inspection here period. So after 15 days, to make sure to show our seller that we're serious, we can add additional deposit here. For example, another $10,000. Financing expressed as dollar amount or percentage. See paragraph 8, loan amount. This is in case if you're using financing. If you're not using financing, your clients using financing or not. If they're not using financing and paying cash for the property, then what you do in the next fields, you don't have anything for financing here. So you can, in the balance to close section, the math is super easy here. You take 90,000 and subtract 10 initial deposit and subtract additional deposit another 10,000, and you will have $70,000 to close. And this has to be wired to the title company at the day of closing or the day before. It depends on what have been discussed. In our case, we will use financing, and we want to finance 50% of the purchase price. In that case, will be $45,000. And you can write it in both ways, expresses a dollar amount or percentage. So 50%, or you can write $45,000, which is 50% of 90. Other, this is in case if there is another deposits involved or there's some stipulations, but in our case we'll leave it blank. Balance to close, not including buyer closing costs, prepaids and prorations by wire transfer or other collected funds. So in our case we will have 90,000, subtract 10, subtract another 10, and subtract 45. So we will have $25,000 left, right? And this will be balanced to close. Next, paragraph number 3, time for acceptance of offer and counter offers, effective date. If not signed by buyer and seller and an executed copy delivered to all parties on or before, here we need to put the date. Until then this offer will be valid, and usually it's, again, depends how many offers sellers already have, or how much time your buyers want to give seller to think about it. Well, in our case, we'll put it for 3 days until Wednesday. Today is Sunday, so 1, 2, 3. And we can write on February 14th by 6 p.m. So if we don't get counter offer or no response on our offer on February the 14th, Valentine's Day, by 6 p.m., this offer will be deemed withdrawn. And you can read it here too. This offer shall be deemed withdrawn, and the deposits, if any, shall be returned to buyer, unless otherwise stated. Time for acceptance of any counteroffer shall be within 2 days after the day the counteroffer is delivered. Letter B. The effective date of this contract shall be the date when the last one of the buyer and seller has signed or initialed and delivered this offer or final counteroffer. Effective date. So when all parties signed and finalized the contract, and there were any additions within the contract, and the effective date considered usually when everybody, both sides, seller and buyer, signed the contract, and if there were any changes, both sides initialed it. It's a very important part. Number 4, closing date. Unless modified by other provisions of this contract, the closing of this transaction shall occur, and the closing documents required to be furnished by each party pursuant to this contract shall be delivered on, and this is the date of closing. Because we have a financing here involved, I want to have at least 45 days to close. So effective date, let's say, will be the 12th, and we were looking at March and 15 days, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 15. So until Tuesday, March 27th. And in case if our financing will get approved earlier, we don't have a problem to close earlier. And in that case, I'll write on or before. So we have on or before March 27th. Number 5, extension of closing date. If paragraph 8b is checked and closing funds from buyer's lenders are not available on closing date due to Consumer Financial Protection Bureau closing disclosure delivery requirements, then closing shall be extended for such period necessary to satisfy CFPB requirements, provided such period shall not exceed 10 days. In an event constituting force majeure, causes services essential for closing to be unavailable, including the unavailability of utilities or issuance of hazard, wind, flood, or homeowners insurance, closing date shall be extended as provided in Standard G. And again, this is all standard, but it's very important to read through it and understand what does it all mean, and because your buyers, your clients will have questions about contracts. So after this video review, please read it a few times on your own and try to fill it out by yourself too. Number 6, occupancy and possession. Unless the box in paragraph 6b is checked, seller shall at closing deliver occupancy and possession of the property to buyer, free of tenants, occupants, and future tenancies. Also, at closing, seller shall have removed all personal items and trash from the property and shall deliver all keys, garage door openers, access devices, and codes as applicable to buyer. If occupancy is to be delivered before closing, buyer assumes all risk of loss of the property from date of occupancy, shall be responsible and liable for maintenance from that date, and shall be deemed to have accepted the property in its existing condition as of time of taking occupancy. Letter B, check if property is subject to lease or occupancy after closing. This will check in case if property is subject to leases after closing, or is intended to be rented or occupied by third parties beyond closing. The facts and terms thereof shall be disclosed in writing by seller to buyer, and copies of the written leases shall be delivered to buyer all within 5 days after the effective date. If buyer determines in buyer's sole discretion that the lease of terms of occupancy are not acceptable to buyer may terminate this contract by delivery of written notice of such election to seller within 5 days after receipt of the above items from seller, and buyer shall be refunded the deposit, thereby releasing buyer and seller from all further obligations under this contract. Estoppel letters and seller's affidavit shall be provided pursuant to standard D if property is intended to be occupied by seller after closing. See Rider U. Post-closing occupancy by seller. In short, if there's a tenant in place, if the property is subject to lease, or the buyers are investors and they would like to keep the current tenants in place, this seller needs to disclose all the terms of the contract and all the terms, the payments, who holding the deposits, and this is the I need to provide the estoppel letter and seller's affidavit too. Paragraph number 7, assignability. Check 1. Buyer may assign and thereby be released from any further liability under this contract. Option 2, may assign but not released from liability under this contract. And number 3, may not assign this contract. So all 3 options. In the case if buyers creating the contract under their name, but in the future or during the contract period they will be opening an LLC or corporation, any corporation, and would like to transfer the contract under this corporation for the purposes of ownership, or they need to tell you that ahead of time. So in the contract you can state that they may assign this contract to newly formed corporation but not be released from liability under this contract. In case if they buying for corporation or under their name and are not planning to during the terms of the contract transfer it under any other names, you can select option 1, option 3, may not assign this contract. And option 1, it lifts the buyer's obligation under this contract, and that it can be assigned to third party. Basically, it says buyer may assign and thereby be released from any third liability under this contract. This usually happens when there is in case of wholesalers, because they will find these deals and then they put it under contract and then they reassign this contract for new buyers. So let's continue. In paragraph number 7, we'll put may not assign this contract because we're purchasing under in our case under my name, and I'm not planning to assign or form a corporation to purchase this place. Next paragraph is financing. Here in paragraph 8, you determine with your buyer what terms of purchase they will pursue. First option is buyer will pay cash for the purchase of the property at closing. There is no financing contingency to buyer's obligation to close. If buyer obtains a loan for any part of the purchase price of the property, buyer acknowledges that any terms and conditions imposed by buyer's lenders or by CFPB requirements shall not affect or extend the buyer's obligation to close or otherwise affect any terms or conditions of this contract. If we were paying cash and there was not financing involved, I would have chosen this option 1. But now in our case, I'll be using financing. So this contract is contingent upon buyer obtaining approval of a conventional loan. In our case, we'll be getting conventional loan within, if left blank, 30 days. I'll leave it blank. After the effective date, loan approval period. So here we need to check what type of rate it will be. I'm not sure yet, so I'll put fixed or adjustable rate. If your clients already have a pre-approval, and in the pre-approval it's stated what terms of financing and what rate they will be getting, you can state fixed or adjustable. Now, in my case, I don't have pre-approval yet, so I'll put fixed or adjustable rate in the loan amount. At initial interest rate, not to exceed. It also depends if you're working with local buyers or with international investors. The rates may differ. I live in Florida. I'm Florida resident and a U.S. citizen, so in here I'll put not more than 6%. Left blank, then previewing a rate based upon buyer's credit worthiness. You can leave it blank as well, but I don't want to get financing for more than 4 or 5%, but just in case I put 6. And for a term of 30 years. Buyer shall make mortgage loan application for the financing within 5 days if left blank. I'll leave it blank. I'll have 5 days to fill out the loan application, and this is more than enough. And use good faith and diligent effort to obtain approval of a loan meeting the financing terms and thereafter to close this contract. Loan approval which requires a condition related to the sale by buyer of the property shall not be deemed loan approval for purposes of this subparagraph. Buyer's failure to use the diligent effort to obtain loan approval during the loan approval period shall be considered a default under the terms of this contract. For purposes of this provision, diligent effort includes but is not limited to timely furnishing all documents and information and paying all fees and charges requested by buyer's mortgage broker and lender in connection with buyer's mortgage loan application. And this language is standard. Please read it on your own. In case if there is an existing mortgage, there is an option of assumption. We're not going to do that. Purchase money note and mortgage to seller. Not doing that. Closing costs, fees and charges. Here you have basic costs to be paid by seller, and documentary stamp, taxes and surtax on deed, owner policy and charges, title search charges, municipal lien searches, and etc. And sometimes here sellers put warranty on appliances or some type of warranty if it's a new construction, so you can it's editable and custom. Costs to be paid by buyer, taxes and recording fees on notes and mortgages, recording fees for deed and financing statements, owner's policy and charges, survey, lender's title policy and endorsements, HOA condominium association application, transfer fees, municipal lien search, etc. Title evidence and insurance. So at least if left blank, then 15. So 15 days, this is good. We can emphasize it with 15 here. Is checked. Let's check. Then 5. Paragraph 8a. If we have 8a checked over here, that buyer will pay cash. That means that 5 by default. In our case, we have 15. Title insurance commitment issued by a Florida licensed title insurer with legible copies of instruments listed as exceptions attached thereto. Title commitment. Now, this part is very important. It has one of the options has to be checked. In our case, because our brokerage located in Miami-Dade and Broward and Palm Beach, if the transaction taking place in Broward County, Miami-Dade, it's usually a third option, and what it says, it's seller shall furnish a copy of the prior owner policy or title insurance or other evidence of title and pay fees for a continuation or update of such title evidence which is acceptable to buyer's title insurance underwriter for issue of coverage. tax search, and municipal lien search. Buyer shall obtain and pay for post-closing continuation premium for buyer's owner's policy and, if applicable, buyer's lender policy. Seller shall not be obligated to pay more than $200 of left blank for abstract continuation of or title search ordered by performed by closing agent. Option 1, seller shall designate closing agent and pay for owner's policy and charges, and buyer shall pay the premium for buyer's lender's policy and charges for closing services related to the lender's policy, endorsements, and loan closing, which amounts shall be paid by buyer to closing agent or such other provider that buyer may select. So in this case, sellers selecting the title company and covering all the expenses in regards to closing. Option 2 is when buyer selecting the closing agent and paying for owner's policy and charges for closing services related to buyer's lender's policy, endorsements, and loan closing. So this is in case if buyer will cover all the closing costs. Usually in our case we have option 3. In Palm Beach County, many contracts are using when the seller is covering all the expenses, but again, this is all customizable. It's up to discussion. You can talk with your buyer and discuss with them. Also, if you're on the seller side and you're presenting counter offer, make sure you know what option is selected, because at the closing table it can be a big difference between this option 1, option 2, and option 3. Letter D, survey. On or before title evidence deadline, buyer may, at buyer's expense, have the real property surveyed and certified by a registered Florida surveyor. If seller has a survey covering the real property, a copy shall be furnished to buyer and closing agent within 5 days after effective date. Home warranty. At closing, there's few options. Buyer, seller, not applicable, shall pay for home warranty plan issued by. Again, this is if you representing buyer and they asking for home warranty on appliances, you need to talk with the seller's agent. I'll put and not applicable. Nobody shall pay for home warranty plan. And in case if it's a bigger house with expensive appliances, I mean, again, this is all just customized. Special assessments. At closing, seller shall pay the full amount of liens imposed by public body and that are certified, confirmed, and ratified before closing. And number 2, the amount of the public body most recent estimate or assessment for an improvement which is substantially complete as of effective date, but that has not resulted in a lien being imposed on the property before closing. Buyer shall pay all other assessments if special assessments may be paid in installments. Check 1. 2 options. Seller shall pay installments due prior to closing, and buyer shall pay installments due after closing. Installments prepaid or due for the year of closing shall be prorated. Option 2. Seller shall pay the assessments in full prior to or at the time of closing. If neither box is checked, then option A shall be deemed selected. So here is very important, letter F. Usually, if there is a special assessment within the building or within an apartment complex, there is an amount which has to be disclosed. If you're representing buyer, preferably that seller pay all the assessments in full prior to time of closing. Again, this depends on the situation. Sometimes seller will not agree to that, and they will send you back the counter and cross that out with option 1, and you have to, both sides need to put initials next to it. In our case, I want seller to pay all the assessments in full prior to or at the time of closing. Next part of the contract is disclosures. You can read it on your own. 1, 2, 3, 4. Let's look at this editable option, because I want to make sure you know where all the editable parts can be can be checked or can be edited. So D, flood zone elevation certification. Buyer is advised to verify by elevation certificate which flood zone the property is in, whether flood insurance is required by the buyer's lender, and what restrictions apply to improving the property and rebuilding in the event of casualty. If property is in a special flood hazard area or Coastal Barrier Resources Act designated area, or otherwise protected area identified by the U.S. Fish and Wildlife Service under the Coastal Barrier Resources Act, and the lowest floor elevation for the building and/or flood insurance rating purposes is below minimum flood elevation, or is ineligible for flood insurance coverage for the National Flood Insurance Program or private flood insurance as defined in 42 U.S.C. Paragraph, buyer may terminate this contract by delivering written notice to the seller within 12 and 20 days after the effective date, and buyer shall be refunded the deposit, thereby releasing the buyer and seller from all further obligations under this contract, failing which buyer accept existing elevation of buildings and flood zone designation of property. So basically need to check with the seller, with the closing agent, with the listing agent, if the property is located in a special flood hazard area, because in our case we will be, in my case, I'm presenting offer with financing contingency, and banks definitely need to have insurance on the property, and in case if insurance can be obtained, then the contract can be cancelled. But it's better to find out about this ahead of time, not to waste anybody's time, because in case if insurance is not eligible for that property, buyer need to pay cash for it probably. So it depends on the bank, on the insurance company. But again, buyer's agent need to find out about the flood, if it's in the flood zone or if it's in the Coastal Barrier Resource Act area, and inform buyer about that. Next paragraph, also standard. Read it on your own, please. Number 12, property inspection and right to cancel. Property inspection and right to cancel, buyer shall have, if you were leaving it blank, 15 days after the effective date, and I want 15 days for my inspection period, and within which to have such inspections of the property performed as buyer shall desire during the inspection period. If buyer determines in buyer's sole discretion that the property is not acceptable to buyer may terminate this contract by delivering written notice of such election to seller prior to expiration of the inspection period. If buyer timely terminates this contract, the deposit paid shall be returned to buyer, thereupon buyer and seller shall be released of all further obligations under this contract. Sometimes sellers don't want to wait 15 days and the listing agent will send you counter offer with 10 days, 7, but in our case, I'm the buyer and representing myself basically here, and I want to have 15 days just to be sure, safe, in case if I call inspector and they can't, they didn't show up, I need to reschedule, and then I have more than enough days to get my report, review it, and make my final decision. Either negotiate on the price more because if there's a lot of repairs has to be done, or the seller can perform all the repairs before closing, or I can cancel the contract. Walk through inspection and reinspection on the day prior to closing date or on closing date prior to time of closing as specified by buyer or buyer's representative may perform a walkthrough inspection of the property solely to confirm that all items of personal property on the property and to verify that seller has maintained the property as required by the as-is maintenance requirement and has met all other contractual obligations. Seller assistance and cooperation in closeout of building permits. Please read it on your own. This is all standard language in the contract. Escrow agent and broker, also this is standard. Default and dispute resolution. Standards for real estate transactions. And make sure you know what each paragraph is all about, because your buyers, your clients can ask you questions and you need to know what this part or what that paragraph is about. Okay, so let's continue, and this is the final part of as is residential contract. So addenda and additional terms. There are many items here, and let's talk about all of them. The following additional terms are included in the attached addenda or riders and incorporated into this contract. Check if applicable. So condominium rider. In case if you're buying an apartment or multi-family unit and there is a condominium, condominiums will provide all the set of rules, and it has to be your buyer need to be aware that there is a condominium rules and set, and the condo association usually will provide it at additional fee. So check it. If in our case it's let's go back to our listing. This is let's see, Tiny Beach County. It's rental apartment condo, so it's a condominium complex. So in the contract we need to state that we need a condominium rider. Homeowners association. In many complexes, if it's townhouse complex, maybe it's a single family residential housing or a complex as well, and many of them have a homeowners association, and there is disclosure which has to be signed along with the contract in order to proceed as well. Seller financing. So homeowners association in case if property is located within the homeowners association. Seller financing, we don't have seller financing in our case, but sometimes there is sellers offering seller financing on special terms. This is up to discussion. Mortgage assumption, again, if seller has a mortgage, the buyer can do a mortgage assumption, not in our case. FHA, VA financing, first home buyers program or veteran affairs financing programs are available, and again, if your buyers are buying with FHA, it has to be checked, or with VA, it has to be checked. Appraisal contingency. This is in case if your bank required that this property appraised to a certain value, and banks usually perform their own appraisal. In our case, bank will do property appraiser of this apartment, so I want to have make sure that it will appraise at the level which bank will require, and at the purchase price. That way the whole sum will be financed. In case if appraisal comes in low, buyer has an option with contributing additional funds in cash towards the purchase, or to finance the lower amount. In our case, because we're only financing 50%, we can finance less. But again, if the appraisal will come in very low or lower when expected, the deal can be cancelled. That's why I put the appraisal contingency. Short sale, in case if the property is a short sale, in our case it's not. Homeowners, flood insurance, this is in case if there's a homeowners and flood insurance approval. For example, remember there was a paragraph before about the flood zones, and there is contingency, so we can have a flood insurance contingency here as well. Reserve, this is the empty space, you can edit it. Interest bearing account, this is in case if there is an escrow account with a certain brokerage and they have an interest bearing account, which means that while the money hold up at the escrow, they will accumulate interest. Ask your broker, ask your title company if they have interest bearing account. There is additional disclosure which has to be provided to buyer and seller. In our case, Vera Realty doesn't have interest bearing account, so we don't have to check that. Reserved. Also, you can add something here if you don't have, but I mean, basically you can edit it. Defective drive wall. If there's a problems with drywall, or if there is a Chinese drywall issue, that has to be disclosed, and additional addendums provided. In our case, no. Coastal construction control line, I need to check zoning and ask seller and listing agent if the property located within the coastal construction control line. In our case, no. Insulation disclosure, if there was certain type of insulation, disclosure has to be provided. Lead-based paint disclosure for the properties which were built prior to 1978. So let's go back to listing and see in what year it was built. It was built in 1981, so we don't need a disclosure. Double check here. The year built is actual 1982, effective 1982, so we don't have to provide lead-based paint disclosure. Housing for older persons, this is HOPA 55 plus, 60 plus apartment complexes. In our case, we'll look at the MLS listing again. I look for information if it's HOPA property or not. It says no, so we don't have to worry about that. Rezoning, if the parcel, house, or the property currently going through the rezoning process. In our case, no. Lease, purchase, lease option. Earlier in the contract, this was discussed as well. So continuing, lease, purchase, lease option. This is when buyer and seller will agree on specific terms that the buyer will be leasing and will have the property and will have an option to buy the property at a certain price and will pay non-refundable deposit, and will have an option to buy the property at a later time for this amount, and the payment will be for option will be included in the purchase price or excluded. And for seller, if seller will sign the option, it means that seller is obligated to sell, but for buyer there is no obligation to buy. If after the expiration of the option the buyer is not willing to purchase the property anymore, he will lose the deposit. In our case, we're not going to select that. But easy example, let's say this property for $90,000, and I will tell the owner, Vera Realty LLC, that I will buy it for $90,000 no later than 1 year from today, and I'll put down $20,000 as a deposit, and I'll have an option to buy it during this 1 year period of time. If I'm not buying it in a year, I'm gonna lose $20,000, and I can reject at the purchase this option at any time, oppositely to seller who can't reject the option and have to execute the option upon the buyer's request. So not in our case. Next one, pre-closing occupancy. This is in case if buyers wants to occupy the property before the closing. Let's say I'm telling the seller in our case that I want to move in before the closing, or let's say March 1st, and I'll pay the $1,000 rent and will stay until the closing. Again, it's not very common, but it happens, but I'm not going to check that. Post-closing occupancy. This is in case if seller asking buyer to stay for another month or two, it depends, and also will pay rent in the amount, and this all have to be disclosed and written in additional terms and addendum. Sale of buyer's property. This is in case if, let's say I'm making an offer on this property, this apartment, and in order for me to buy it, I need to sell my apartment where I'm staying right now. And with an additional addendum, and you need to check here that in case if I'm selling my property, I'm buying this one. Again, this is not very common, but also this contract sometimes takes place, and in case if the buyer is presenting very interesting offer, and in case if seller, they don't have anything else on the table, they had property for a long time in the market, they sometimes taken that risks. Also, there is a backup contract clause. That means that this is a backup contract which we're submitting, and it has to be signed, and it will be next in line. If there are a few backup contracts, it will be the seller, and seller's agent has to disclose where you're standing, at what, after whom you are in the line, or if you are next in the line, and the seller agent need to inform you if the current contract will fall through, yours will be the next one, second, third, etc. In our case, it's not a backup contract. Kick out clause. So what's kick out clause? If we have this one checked, so sale of buyer's property, and in case if seller will say, okay, I will accept this contract, but if I will receive a better offer without sale of buyer property contingency, this contract will be deemed cancelled, and that means, kick out. So basically, they're kicking out this contract with the sale of buyer property contingency and taking the regular contract without contingency. This contingency. We don't have none of this in our case. Seller's attorney approval. This is if there is a need of approving the contract by the seller. Buyer's attorney approval, if there is a need of attorney to approve the buyer's contract. Licensee property interest, I will check that because I'm the licensed broker and I will be buying property for myself and I have a license. So we need to check that. Binding arbitration, you need to check that if in case if there is an issue or case goes to court, it will be solved within arbitration. Again, this is not a legal advice. I'm not a licensed attorney. So if you have any questions in legal about legal parts of the contract, please contact your lawyer or send me email, and I will recommend you a real estate lawyer, an attorney. In additional terms, so next, moving forward to additional terms, and we're almost at the end here. In additional terms, you usually write additional clauses, or in our case here, Vera Realty is acting as an escrow agent in the sale transaction between buyer and seller, and seller has the consent of the parties to deposit the escrow funds into a non-interest bearing account with a financial institution chosen by Vera Realty. This is because Vera Realty is represented here as an escrow agent. So I want to put this disclosure here. Anything else about inspection, about clauses, you also can put over here. So moving forward, and every page has to be initialed, and I'll show you how to do that too. Only if you use .loop, that information will be helpful, but also .loop has specific course and the tutorials on how to use their system. So we'll put a date here. Calendar is not working for some reason, but we can just type it in. Today is February 11th, 2018. Okay, so the addresses are up to you. You can input them, you don't have to. And the final part is cooperating sales associate, if any, and listing sales associate. So over here, I put my name, cooperating broker. And this is us too, Realty LLC. Then listing sales associate. Usually you'll find it on MLS. So in our case, it was Vera Realty LLC as well. Sorry. I mean, we'll put the listing sales associate as Vera Realty LLC because we don't have anybody here, but your name will go here, or I mean the seller's agent name. Let's say John Realty, and then you can save it. Then you need to add buyer to the loop and assign buyer initials to every page and send the signature request. Or your buyer can come into the office and sign it in person. But there's initials on every page of the contract. And page 5, so every page has to be initialed and signatures at the back. First buyer sign, then you send it to listing agent, and then if they don't have any comments and they agree to the terms, then seller sign, and that means you're under contract. Again, and after you finish filling it out, make sure you review every single field, every single page. Make sure you know all the terms and all the paragraphs in the contract, because your clients will be asking questions and you have to know and be professional. Thank you for watching. Email me if you have any questions, and have a wonderful day.